So welcome to this OECD side session on contracting for human rights, aligning international supply chain contracts with the UNGPs and OECD guidance. I'm Olivia Wyndham-Stewart. I'm an independent business and human rights specialist. I'm also senior fellow and deputy director of the Business and Human Rights Law Program at the Center for Corporate Law and Governance at Rutgers Law School in New Jersey. I've also been involved in the project to draft model contract clauses to protect human rights in international supply chains for 2 years or so now. So we'll come to that project later and you'll be hearing more about it. I'm going to start the session with just a few housekeeping notes. First of all, the session is 60 minutes long, as you know. It is the last session of the forum, so well done for making it through and for joining us today. We are going to keep it pretty informal. We'll have a good section for Q&A at the end. And we really hope you enjoy it. And we're planning to record this and make it available to you after the session. So please also feel free to share it widely or to watch it again if you're so inclined. And as I'm sure many of you are aware, it won't be your first webinar, we have a chat function at the bottom of the screen and also a Q&A function. So please do make use of those whenever needed. And if you'd like to introduce yourselves in the chat, your name and your organization, you're very welcome. We will also have quite ample time for Q&A, so please don't be shy with your questions. No matter how basic, this might be a new topic to many of you, so please do throw all your questions in there, or even if you want to get very nitty-gritty on some of the detail, please feel free. If there are participants in the group, we know we have a few people who are watching who are also in the working group. If you see questions that you feel inclined to respond to, thinking of David and Sue in particular, please feel free to also jump in the chat and talk amongst yourselves while we're presenting and doing the panel, because we do want to kind of bring everyone in. Okay, so now we've got housekeeping out of the way, we can turn to the session. The session, as you know, focuses on contracts, the contracts between buyers and suppliers in international supply chains. Now, contracts are, of course, part of the purchasing practices universe, both in that contracting practices and negotiations form part of the purchasing dialogue between a buyer and a supplier, and also that contracts are the place in which the terms of the purchase are specifically spelled out and made binding. And as is commonly the focus when we consider purchasing practices, our concern here is how contracts and contracting practices impact on human rights outcomes in supply chains. So how the business to business relationship, the commercial relationship between the buyer and the supplier, and the way this is structured in the contract may impact on labor rights, even environmental conditions in supply chains. Although today we are focusing on human rights. You may have actually seen on Wednesday that the EU's draft due diligence bill includes an article, Article 12, obliging the Commission to provide guidance on model contract clauses. Now, the message of this session, I don't want to kind of offer too much of a plot spoiler, but the message of the session is that not all contractual clauses are, in our opinion, created equal. And depending on the approach taken by the contracting parties, certain contracting practices and contractual clauses can actually work to exacerbate, in some circumstances, human rights risks in the supply chain and even undermine a buyer's own human rights commitments. Now, alternatively, taking new approaches to contracting and crafting the right sort of contracts has the potential to vastly improve outcomes for workers and the environment. I'm going to sort of reference a comment by Matthias from the International Apparel Federation earlier in the forum. He said this about purchasing practices, but I think it applies to contracts more specifically. He said that we can think of contracts as a bridge across which a buyer's intentions must travel, which I really, really liked. And the question here today is how we sort of best build that bridge. What are the best clauses, the best kind of bricks to make our bridge that can get us over that bridge to realize the best human rights outcomes. So the session will begin by exploring some of the current approaches to contracting and the commercial, the legal, the social implications that can arise from those. And we will then move to introduce the model contract clauses, version 2, which have been developed by a working group of the American Bar Association Business Law section, and think about some of the productive and positive ways we can move contracting in supply chains forward to better protect human rights. The MCCs that we will introduce you to, the model contract clauses that have been drafted specifically to help buyers and suppliers redesign their contracts to help better protect human rights in their supply chains. They're the first model contract clauses that attempt to fully integrate the principles contained in the UNGPs and the OECD Due Diligence Guidance into international supply contracts. So what better place to discuss them than at the OECD Forum? And what better week than the week in which the EU has called for guidance on model contract clauses as part of the due diligence bill. So with no further ado, I will turn to the panelists who have very kindly joined us today to discuss some of these issues with us. First, we have Fatima Zora Alawi. Fatima is the General Manager at AMIF, the Moroccan Association of Textile and Apparel Industries, which has played a key role supporting the Moroccan textile and garment industry since the start of the COVID crisis. AMIF is also a member of the Sustainable Terms of Trade initiative that many of you may have heard about in the course of the forum or prior to this week. We are also delighted to be joined by Megan Bannigan. Megan is partner in the litigation group at Debevoise and Plimpton. Megan also teaches fashion law and intellectual property at Rutgers and the NYU law schools. And last but not least, we are joined by my colleague, Sarah Dadouche, Professor of Law at Rutgers and Director of the Business and Human Rights Law Program at the Center for Corporate Law and Governance, and also co-lead of the American Bar Association Business Law Section Working Group to draft version 2 of the model contract clauses to protect human rights in international supply chains. So we're going to start our discussion with Fatima. Fatima, we would really like you to just help us set the scene. You're working in Morocco, you're working every day with suppliers. Could you perhaps help us understand some of the typical sourcing and contracting practices that are employed between international buyers and Moroccan suppliers?
Thank you, Olivia. Hello, everyone. It's a real pleasure to be here today and be able to share with you the experience from the manufacturer side from Morocco, and also in general how it happens, like you said. Today, I think everybody is aware that we do have a clear imbalance in the contracts between the buyers and the producers. And this imbalance is obviously in favor of the buyers. And what we think is important is that the buyers need to understand that this imbalance, like you mentioned earlier, it creates a real risk for the producer not respecting basically the workers' social rights, because there's so much pressure, and I'll go back to that later on, that they could be forced to overcome or go over some of the workers' social rights in order to be able to meet the requirements of the buyers. And this overall situation would go basically against also the commitment or the pledge of the buyers today. And we see that all over the world, all the brands, all the retailers today are making commitments in terms of sustainability, both at the social and the environmental level. So on the one side, they're saying, okay, we need more and we pledge to be more socially sustainable with regards to their consumers. But at the same time, the way it works today in the supply chain create risks not to be able to be sustainable on the social standpoint. The situation or this imbalance, in my sense, has worsened since the start of the COVID. So briefly, basically, there is pressure, and this pressure has been there for a very long time. It's not new, and it's not proper to Morocco. Like you mentioned earlier, AMIF, the association that I represent, is part of the SETI initiative. And we discussed with 11 other manufacturing countries, 10 other manufacturing countries, and we seem to all share the same problems. There is a pressure on manufacturers in terms of lead times for the production. The buyers, especially with the fast fashion trend, the buyers want the goods to be produced quickly in order to be able to put them on the shelves very quickly, and they need new collections and so on on very short lead times. This is the situation. This was the situation already before COVID, but now with the COVID, it got even worse because they want the goods even faster in the shops in order to be able to sell them, because there is also a lot of competition between the brands and the retailers today. So they want the goods to be even faster in the stores, which puts a lot of pressure on the manufacturers, sometimes require them to have the workers work extra hours, work on weekends in order to be able to meet the deadlines that are set by the buyers. So that's one of the problems. Another problem that we see is the pressure on the prices. Competition between buyers lead them to put pressure on the manufacturers in order to always get the lowest price on the product. It was already the case before, but it simply got worse with COVID. We feel even more pressure on the prices because, well, they found themselves at some point with the lockdowns and everything, they found themselves with the big inventories that they needed to discount in order to sell them. And then we didn't know if consumers wanted to spend money on clothing because everybody was on lockdown, staying home, not going to work and so on. So prices were going down, and all that pressure basically was put on the manufacturers. We've also witnessed over that period an increase in raw material, an increase in shipment costs and everything. And the position of the buyers was that, I don't care. You have to bear those increases. All I care about is I need to have this blouse, this pants at this price. I don't care about the rest, which puts a lot of pressure on the manufacturers once again, who needs to find ways to get those garments out of their production chain at the prices that the buyers require. And then there's the pressure in terms of just the interaction or the relation. Most of the time, and I'm talking about Morocco, but I'm sure it's the same in other countries, we don't have formal contracts. There's no formal contracts. The buyers have been here for a very long time. They know the suppliers and so on. So today the orders basically are passed over the phone or by email. There's no formal contract. So when there is a problem, there's no legal base on which the manufacturer can defend himself and get the buyer to comply with the commitments that were made initially, because there's no formal contract. We had situations during the COVID period where buyers simply decided to cancel the orders, and the manufacturers couldn't do anything. They were faced with orders that they made. They bought the fabrics and everything, but the buyers just decided to cancel the order or to apply discounts that were not agreed before on the basis that it was take it or leave it. What could the manufacturers do in this kind of situation? So basically, the overall situation shows that there is a clear imbalance today between the power of the buyer and the power of the manufacturer that needs to be rebalanced in order to have a more equal partnership between the two. And the buyers needs to be aware that all the pressure they put on the manufacturers will definitely have an impact on the workers' social conditions and social rights, because the manufacturers basically don't have a lot of room where to navigate in order to maintain those rights.
Thank you, Fatima. Yeah, it's a problem that I have been hearing about for many years, with very little progress, which is, I remember going to factories, years back, and suppliers saying to me, you're right. I mean, the human rights standards that they put into their contracts, the policies they have, it's all top of the line, best you could possibly ask for, but you should see their contracts. You should see their commercial practices. You should see the pressures they put us under. And these are the sort of tensions that we're looking to think about today. I also heard a really, really interesting example earlier in the week of a brand that was trying to engage in reasonable contracting with its suppliers, and then realized that the other brands were putting them under so much more pressure that their orders were getting pushed to the back of the queue. So then they had to make their contracts even more aggressive than the other ones. So we have this case of contracts, a race to the bottom, even in contracts, which is not going to help human rights. I think we can all broadly agree. Thank you so much, Fatima, and I hope we can come and talk more about this through the session. Now, Megan, we've heard from Fatima about how this is causing problems for suppliers and consequently for workers. From a buyer's perspective, how do you see the liability landscape changing for environmental and social performance in the US? And how do you see contracts fitting into this changing liability landscape?
Yes, thank you. So I'm going to change the focus a little bit and think about it from the consumer perspective, because there's also, Fatima just gave us some really great reasons why model contract clauses are so important. But really, businesses should not be so adverse to them because there's lots of ways they can help. And so let's think about it from the consumer perspective, stepping back a minute. It has become so apparent lately that consumers are paying attention and want to support brands with moral consciences. The fashion industry is no exception. Look, there's not exactly a great track record for being environmentally friendly or traditionally focused on sustainable goods. And they're doing a lot of new great things to tout their new sustainability principles. And consumers care about this. There are brands that have popped up left and right that are clean brands, that are sustainable brands. Consumers are loving it. And what you're seeing is brands are becoming really eager to tout their new sustainability practices, whether it's a business built entirely on sustainability or whether it's a long established business that has changed some of its practices. But along with these new sustainability claims, there's a risk that these marketing campaigns are going to be impacted by the concept of greenwashing, which I'm sure we're all familiar with here. And that's when a brand eager to tell its stakeholders what it's doing in this area intentionally or either unintentionally misrepresents or exaggerates its its ESG activities. And obviously this can lead to reputational backlash and legal scrutiny. But what we're seeing is really, aside from the reputational backlash, legal scrutiny is becoming a real issue. And let me give you some examples of what's happening here to put this in context, and then we can bring it all together. I'm going to try to share my screen. Let me see if this works. All good? Okay. Okay, so here's an example of a class action litigation that was recently brought in the United States. Class actions, for anyone not familiar with the United States legal system, it's when a group of plaintiffs will bring a suit together. And these are the most tedious and potentially expensive lawsuits that you can have in the United States because they are hard to defend. There are lots of plaintiffs and they can be really, really costly for a brand. And the idea is that there's one suit where consumers can remedy any problems that they're having. And so here's an example where plaintiffs brought a class action suit against Allbirds. And if you're not familiar with Allbirds, this is the startup turned $1 billion brand that's essentially turned having earth-friendly wool sneakers into a legitimate product category. And the plaintiffs allege here that Allbirds aren't living up to the claims that it makes in its sustainable centric marketing. So Allbirds, for example, advertised that its wool harvesting practices are sustainable, that they're humane. It claimed that its sheep were happy, and even bigger, it promoted what's called this life cycle assessment tool, which purports to identify the carbon footprint of each product that Allbirds sells. And plaintiffs took issue with each of these claims and claimed false advertising in this class action litigation. With respect to the life cycle assessment tool, they said the tool doesn't assess environmental impact beyond the manufacturing of the shoes. And they actually said you have to look at the underlying suppliers. It's not just what you, Allbirds, it's doing, it's what your suppliers are doing. And wool production, we have to look at the impact of wool production, including the impact that it has on water, on eutrophication, on land occupation. And thus, you might say you have this life cycle assessment tool, but they claim that it's excluding almost half of the wool's environmental impact. And again, it might not be what Allbirds itself is doing with the wool, but where is the wool coming from and what is the environmental impact of how that wool is being created? At the same time, the plaintiff claims the carbon footprint figures are based on a conservative assumption for each calculation, skewing the calculations in its own favor so it can make more significant environmental claims. And then they also take issue with this happy sheep claim, and they say, look, how can you claim that your sheep are happy? This is a human rights issue. Where you're getting this wool, these are these large scale wool operations, and they have these processes for slaughtering sheep that are neither sustainable nor humane. And look, we don't need to get into all the gory details, but they obviously allege this does not make for a happy sheep. And so Allbirds filed a motion to dismiss. That's pending. One way or the other, however, what this case shows is, these are ambiguous claims. What is a happy sheep? What is when is a life cycle assessment tool to say what my carbon footprint is? How do we know if it's ambiguous, if it's unambiguous? This is becoming a real issue in the United States. These types of claims are not going away. They're going to get very expensive for businesses. Consumers are going to pay attention because to the extent a company, not only are they expensive, but to the extent a company gets found liable of something like this, the consumer is going to lose trust at a time where sustainability and trust is so important. And what we need to think about is, how can we use our contracts? Are there representations in the contract that can potentially help you one way or the other in order to potentially avoid some of this liability? And let me give you an example. So Canada Goose is another company. It's a Canadian-based company, obviously, but this is the U.S. Outlet of Canada Goose. It's this is another case. There's similar claims in a class action litigation brought in New York. Here, Canada Goose claims they're ethical, responsible, they have sustainable sourcing, and a judge didn't even entertain the motion to dismiss. This goes into this Canada Goose fur transparency standard. You see a picture of some of the representations that they make here. And the plaintiffs again called foul. They said that Canada Goose's suppliers actually use cruel methods like legal trap holds and snares that cause, actually I won't even get into it, but with these animals, but these are bad practices. And Canada Goose said, these claims, you haven't stated an actual claim. The claims are too general to be proven or disproven. There can't be a lawsuit based on this. And the judge said, I'm not even going to entertain a motion to dismiss. We need discovery to look into this. This is going to be a very long and a very expensive process for Canada Goose. The one thing the judge did say, however, is that there were certain claims that Canada Goose made that it is in compliance with specified sourcing standards, and that it sources from licensed fur trappers that are regulated by state, provincial, and federal standards. And the court said, look, if you're dealing with specified sourcing standards and state regulations, those are accurate statements, and therefore they can't mislead consumers. And so what that means is some of these bills that are pending, the EU directive that is pending, the New York Fashion Act that is pending, the standards that those directives and bills set out, they're going to be very important to these types of litigation. There are other examples. I don't want to keep getting into all of these. Here's an example of and I'm not going to go into the details of this one, but there were claims brought against Everlane, the cosmetics and skincare company. These claims were not brought in court in the United States, but they were brought by a competitor before the National Association, the National Advertising Division. So competitors are also suing competitors over this, which can be a very, if you get sued in the NAD or a proceeding started in the NAG in the United States, it can be very annoying, and it provides ways for competitors to help competition or hamper competition, depending on how valid the claims are. But look, the point is what can we do here? Are there better contracting principles and processes that can help avoid some of these issues and can keep the consumer trust, keep, consumers happy, but also foster a better relationship between suppliers, vendors, and the actual buyers, to make it, where liability is lessened because there's more due diligence happening. And I think, I will turn this back over to Sarah and Olivia to expand on some of these principles more, but hopefully we can have a conversation around it.
Thank you so much, Megan. I think what's really interesting, what's coming through for me in what both of you say, is that there is a concern on the supplier side and the consumer side about the gap between what companies say and what companies do. And it's precisely this gap, Sarah and I call it the coherence gap, and she'll go into it a little bit, but it's precisely these gaps and these tensions in contracting practices that we think create, in the end, more risk for companies when they're trying to manage their supply chain. Now, as I mentioned at the beginning of the session, Sarah has been co-leading the working group of the business law section of the American Bar Association to draft version 2 of the model contract clauses to protect human rights in supply chains. Sarah is going to introduce you to that toolkit and talk more about how we think that the contracting practices and the contractual clauses that we have developed might address some of the issues and some of the discord between what companies are saying and how they're trying to approach human rights and how they are managing their contracts. So Sarah, over to you.
Thank you so much. Yeah, so listening to Megan, it's so interesting to hear about how the liability landscape really seems to be shifting around companies' claims of being good or doing good, not just in their products but in the making of their products. And I think when we see what's coming out through the EU directive and the responses to the emergence of new legislation from corporations, we can imagine that there would be a really big temptation for corporations, buyers, brands, especially in the fashion industry, to use the contracts to offload responsibility for respecting human rights and so on onto their suppliers. And that really, to our mind, is antithetical to the goal of improving respect for human rights across supply chains. And it's really antithetical to our approach to developing these model contract clauses. And part of what I hear Megan saying is that if you don't balance responsibilities, and Fatima too, if you don't balance responsibilities more fairly between buyer and supplier, then your contracts just won't work. Offloading responsibility onto the suppliers just won't work as a way to reduce human rights risks. If you really want to manage human rights risks, you should actually take measures to reduce them, which means in part having fairer purchasing practices and fairer contracts, which in turn brings in human rights due diligence. So I'm just going to share this slide to give a little bit more background on how we approached developing these model contract clauses as part of our work with the ABA working group. The sort of foundation for version 2.0 is the principles that are laid out in both the UNGPs and the OECD guidance, which say that all businesses have a responsibility to respect human rights, right? No matter where they are in the supply chain. And that requires them to avoid causing or contributing to adverse human rights impacts, whether potential impacts of forward-looking or actual impacts that have materialized, right? Actually occurred impacts. And that piece, especially of the contributing to, brings in purchasing practices. So one way that companies can contribute to adverse human rights impacts is through irresponsible or bad purchasing practices. And this leads us to the observation that within the UNGPs and the OECD guidance, there is a key principle that comes out, which is all companies share responsibility for respecting human rights. And that includes going all the way up to purchasing practices and contracting practices. What the UNGPs don't tell us is what does shared responsibility contracting look like, right? And so this is the task that the working group set out to achieve, is give a shape to shared responsibility contracts. The model contract clauses that we developed, there are 33 of them. They're modular, they can be adapted, edited to suit the company's needs. They're also pan-industry, so they can work for fashion, but also any number of other industries. Are one example of what shared responsibility might look like. We refer to them as a kind of Google Translate to translate the UNGPs and the OECD guidance into contractual language and obligations. So we took the OECD guidance and the UNGPs as our starting point, one of our starting points rather, in developing the MCCs. And like Google Translate, you know, the translation isn't always perfect, but it is, we feel, a good start to understanding what, to rethinking contracts as a tool for improving the human rights performance of supply chains. So what does this look like actually in terms of the clauses? I have here a little chart that just sets side by side what conventional contracts do, how conventional contracts approach human rights and social performance, and how human rights due diligence contracts rooted in the UNGPs, the OECD guidance, as exemplified by the model contract clauses look like. So the key, one of the key, and I break up the distinctions into three key buckets. The first one is that conventional contracts tend to just put all the responsibility for human rights on the supplier and say that just the supplier has to represent and warrant that it is in compliance with all of the buyer's human rights policies and standards. This is effectively asking the supplier to make a representation that if they aren't in compliance with it, they would be in breach. And it's a representation that is actually impossible to make. How can you say categorically throughout the life of this contract, there will be no issues of involving workers' human rights in our contract? It's just not a realistic representation. So the alternative that we come up with is to say, rather than just supplier, both buyer and supplier commit to engaging in ongoing stakeholder-focused human rights due diligence. And if one or the other party fails to do this, that does not alleviate the responsibility of the other one to continue carrying out human rights due diligence. So it's a binding obligation for both parties throughout the life of their engagement. Another key distinction is that conventional contracts, as I said, place the entire responsibility on the supplier for respecting and upholding human rights standards. That means that only the supplier can breach, right? Only the supplier can be in breach of contract. And typically, where there is such a breach, the buyer is allowed to terminate immediately the contract without considering, you know, the impacts for human rights on its decision to terminate. So we move away from that to a bilateral shared responsibility framework that basically says, you know, both parties commit to supporting one another's human rights performance, and on the part of the buyer, commit to supporting the supplier's human rights performance and to not interfering through its purchasing practices with suppliers' ability to uphold human rights standards. So in the MCCs, we would suggest that buyer undertake to engage in responsible purchasing practices, including responsible pricing, negotiating responsible pricing terms that are at least sufficient to cover the cost of production and wages in particular, and responsible business conduct should also be included in there. Buyer should also provide reasonable assistance to supplier in meeting buyer's own human rights standards, and that assistance can be financial or technical or in kind, what have you, whatever is needed. And also, if buyer wishes to change its orders, which we heard, Fatima speak to, or modify the payment terms in the contract or things like this, it must do so in conversation, collaboration with supplier, and consider the human rights implications of its change orders and modifications, and find ones that don't compromise the supplier's ability to respect and uphold workers' human rights. A last point of distinction that Fatima also drew our attention to pertains to responsible exit. So in the MCCs, we say that if a buyer, for whatever reason, including a force majeure event like COVID, wishes to exit a contract, it has to do so in a way that considers the human rights implications of its decision. They have to take measures to mitigate those implications, and they have to pay any outstanding invoices that may have been accrued prior to the decision to terminate, so that the supplier's expenses are covered as contractually agreed. And a last bucket of distinction between conventional contracts and MCC-aligned contracts pertains to remediation. So typical contract remedies tend to say, if there's a breach, the remedies will flow from the breaching party. In conventional contracts, that would be the supplier, to the non-breaching party, meaning the buyer. And that system really does not work where the harm pertains to workers' human rights. In such situations where there is a social breach of contract, human rights remediation should come ahead of and before any traditional contract remedies, and should flow not to the buyer, but rather to the victims, right? And so we have set out a few provisions in the MCCs that go to human rights remediation over typical contract remedies. And they add, when we get to typical contract remedies, we add a caveat that the buyer's remedies will be limited to the extent that they contributed to the adverse impact through their own purchasing practices. So there is just shared responsibility throughout the MCCs, and also just with respect to remediation, if buyer contributed to the harm, then buyer must participate in providing remedy to workers. So this is our approach to contractualizing shared responsibility principles that are enshrined in the UNGPs and the OECD guidance. And with that, I will turn it back over to Olivia. Thank you.
Thank you, Sarah. Thank you very much. I would like to invite Fatima, having heard what Sarah has said about our revolution in contracting. I would like to just hear some reflections from you on how you think that might perhaps help suppliers, not only in the business relationship, but also to protect human rights better in their supply chains if we adopt that shared responsibility model in contracting.
Thank you, Olivia. If I may, I would just like to reflect on what was said earlier by all of you, Megan, yourself, and Sarah, in terms of this sustainability claim and the coherence gap that you mentioned. Actually, during the beginning of the COVID crisis, it really appeared that this was only a claim, in the sense that in practice, what happened is that the buyers, because of COVID, simply decided to cancel all their orders all over the world in a heartbeat, which left millions of people jobless and with no revenues. We had the chance here in Morocco, because the orders were really canceled overnight, we had the chance that the Moroccan government set up an allowance for the workers who couldn't work because of the COVID pandemic in order to give them money to live during that period where the factories were closed, but the buyers simply didn't care. They simply canceled orders. And what happened is that you had representatives from manufacturing associations all over the world coming out and making public this behavior. And this is the only reason why the buyers at that time were forced to step backward and provide compensation to the manufacturers for the canceled orders. So there is indeed a big coherence gap between what is said and what is put in practice in the reality. And that exit decision, the buyers didn't measure the impact of it on the workers. Because when the factory is closed and the owners couldn't pay the salaries, well, people found themselves without money for several months, which is not acceptable for a brand that pretends itself to be sustainable. And the problem in reality in the brands is that the people in charge of sustainability are different from the people in charge of the buying. So you could have within the same company, two different departments speaking a different language with different objectives. So the sustainability people will set up all these standards, all these audits that are put in place and forced on the suppliers to comply with. And on the other hand, you have the buyers, all that matters to them is to buy at the lowest possible price in order to increase the margin for the brand. So there is a complete contradiction inside even the companies, the buyers. And this makes it even more difficult in order to put in place a more sustainable purchasing practice that would indeed protect the rights of the workers. And to go back to your question today, I think it is important, if I had to make a sort of wish list, and this is something that we've discussed within the Sustainable Trade Terms of Trade Initiative, what could be some of the measures to be put in place? One of them is, first of all, develop a supplier's contract, because all the buyers don't work with contracts today. So we need to formalize a standard contract that everybody would apply. That's something important with specific recommendations in terms of commercial compliance, buying practices, and so on. And also, we need someone to monitor all this, because if you leave it between the buyers and the manufacturers, we know the power is not the same and it's not going to be applied. So we need someone, an independent body, to be able to monitor the compliance to the contracts, and at the same time, having some sort of independent arbitration mechanism where when those clauses in the contract are not put in place or respected by the buyers, the manufacturers can go to this arbitration body and not fear retaliation afterwards as well, because that's important as well. And finally, I think, and that's something that we manufacturers need to do, we need to work together and coordinate between us in order to make sure that this works. Because if everybody apply these recommendations, it's going to work. But if they're not applied by everyone, then we will have buyers moving from one country to the other, depending on how constraining it is for them to jump from one country to the other. And that's important. And we could do also, what we could do as well is set up some sort of database where we could record all the malpractices so that everybody knows about it. I'm not talking about the name and shame, but this is something important because we have cases today of buyers who would go to one country and apply very bad practices. And once they kicked out of that country, they would go to another one and repeat the same behavior. And in the other country, they don't know about it. So what we need to do is be able to share among us, among the producing countries, these kind of malpractices in order to avoid to have them spread all over the world.
Yeah, thank you, Fatima, for your reflections. One of the I'll just touch on a few of them quickly. One of the interesting things that has happened since we have published the toolkit is that ethical teams have come to us and said, oh, fantastic. Can you please come and talk to our legal team? Because we're not equipped to do that. We're not usually in the conversations about contracts. We don't get involved in those conversations. So moving into the realm of contracts, we hope is allowing us to create a space where the procurement team, the legal team, the ethical team can sit together and have those sorts of conversations. And as you say, I think it's a very exciting time for suppliers to be coming together and thinking about what does a good contract look like, and how can we help define that together. We're almost at the end. So I just want to ask Megan very quickly to offer some reflections. I mean, the response to some of this is sometimes like, why would a company take on more risk? Because traditionally contracts have been designed to do the opposite. So from your point of view, how could this actually be helpful for companies going forward?
I mean, look, the bottom line is it creates a space to make representations to your consumers without fearing legal repercussions. And, you know, the examples I showed before, while some are on point, some are not directly on point, the point was, you know, these claims are happening, consumers are making these claims, whether they're environmental, whether they're social, human rights, they are going to happen. They're not going to go away anytime soon. The plaintiff's bar has picked up on them and we're going to see them happen. So, you know, really think about your contracting, think about what statements you can make, enter into responsible contracts, and then you can tell your consumers about them without fear of repercussions or fear of making ambiguous claims and setting yourself up to liability. Your consumers care about this, so you have to care about it. And this is one solid way to make the claims and, you know, to win and check all of those boxes.
Thank you, Megan. Yes, I think that it's going to require a slight leap in companies' understanding of what risk is, and what risks in their supply chain look like, and an acceptance of the fact that it's better to get ahead and get out and actually engage with your risks rather than simply ask suppliers to tell you that there are none, because that, as we've seen, will come back and bite you, whether you say you have no labor rights abuses or whether you say you have the world's happiest sheep. You may not, and it's better to acknowledge that you may not and actually take on some of the responsibility for managing that, than to pretend everything's completely fine. I would like to just look at the questions very briefly. Please feel free to put any questions in the chat that you may have about contracts. We did have a question about the term due diligence. We have put some comments there about the definitions of due diligence and where you can go. And also thank you, Dorothy, for putting some links in to understand better what due diligence is and what it means and what companies might be expected to do. A question here from Paul: are we measuring human rights performance in terms of the overall supply chain? If so, what factors are used to measure, how measured, and how to isolate the particular supply chain we're measuring? Where are we focusing? Sarah, perhaps you would like to speak to how we can cascade due diligence through the supply chain and how this will approach that issue.
I think you can. I think you started. Would you mind continuing with that?
Yes, sure, that's fine. Paul, I don't know if this answers your question, but essentially we are asking buyers to cascade due diligence through their supply chain. So to really understand where the risks are. Now, due diligence should take a risk-based approach. So you should be looking as far as possible at the highest risk areas in your supply chain, and the due diligence obligation should be cascaded down to the deeper tiers. I don't know if that, Sarah, do you want to add anything to that? Or
yes, just to say that human rights due diligence is less about it's more about processes than outputs or outcomes even. So it is it's designed to be this sort of ongoing process whereby companies are looking in a continuous way at their supply chains and making assessments, spotting in their supply chains where are the most serious risks to human rights, and taking measures to mitigate those risks, to prevent them from materializing into actual harm. And then if they do materialize into actual harm, then human rights due diligence also includes an obligation to remediate the harm. So it's less about, measurement than it is about instilling processes of ongoing stakeholder-focused processes of assessing performance. I hope that helps clarify a little bit too.
Great, thank you. And then Ruth, you ask, what are the main differences between sector-specific clauses and general ones applying to more sectors? Again, I can ask Sarah also to comment on this, but I would say we have developed these as pan-industry. They are clauses for the sale of goods, so it is really directed at manufacturing, but they can be adapted and applied to your particular sector or the particular, to make them more specific. Sarah, do you want to add to that? No, fair enough.
Yes. Mm-hmm.
And where, okay, so coming back to what Fatima said to arbitration, where, how could this be done in praxis? I believe this is a burning question amongst the STTI group. Fatima, do you want to comment on that?
Well, I don't have much to say. Like you said, it's a burning question. It was an idea that popped up at the time of the working group. Was just trying to figure out how to put it actually in practice, because we have so many different laws, different countries, and so on. So that's something.
I've heard on the grapevine there might be an upcoming event that will be addressing the issue. I don't know exactly when it will be, but I do know that people are working behind the scenes to kind of kick off this conversation about what arbitration could look like. So it's a bit of a kind of watch this space, because there is clearly an appetite for it. There are examples of ways to manage that sort of arbitration process in the supply chain. So I think it's a really interesting new area to explore. Let me just look in the chat quickly. Sarah, would you like to comment on whether the model contract clauses are applicable to non-common law countries and the best way to deal with the global nature of contracting and the choice of law?
This is very unfair of me, but I just gave David, if you wanted, the possibility of unmuting and speaking.
David's been released into the conversation. David, do your worst.
David, we should say, is the chair of the working group, the ABA Business Law Section Working Group that has, produced these model contract clauses.
Can you hear me, Sarah?
Yes, perfectly.
Okay. So the clauses work not only under US domestic law, but under international commercial law. There's a treaty that many countries are party to called the UN Convention on Contracts for the International Sale of Goods, or the CISG. And the current version is made so it works under both. You have to like choose the right language, but we've got it in there so the lawyers can just use the appropriate language. And so many countries that will take care of it. We also have a European working group that is currently working on a European version that will both take account of what's coming out of the EU with respect to corporate sustainability due diligence, but also the civil law systems prominent in Europe and much of the world. The short answer is yes, it should work now, and there will be something even more purpose-built in the coming months, probably over the summer or later in the year.
Thank you, David. Ruth, I see that you want to come back to this issue, which I think is important, about agriculture. And the comment I want to say that I failed to make previously is that the model contract clauses and the way we're proposing companies approach contracting is we're really proposing an approach. So it's less to do with the specifics and more to do with the approach that companies are taking. So we're saying to companies, don't just ask your supplier whether they're supplying clothing or whether they're supplying coffee beans. Don't just ask your supplier to tell you there's nothing wrong in their supply chain. Actually engage with your supplier, take on some of the responsibility for those outcomes. And when the buyer takes on the responsibility, I would wager a guess that the buyer is going to take the risks much more seriously. Because at the moment, if the buyer can abdicate responsibility for any of those outcomes, the actual circumstances are thought to be less important. So we're really, the model contract clauses are proposing an approach rather than a sector specific detail. But as I'm saying, when we're talking to Fatima, we are talking about creating more sector specific detailed clauses and kind of guidance that are really applicable to the particular issues in the garment industry. So those would be issues like delays, like payment terms, like paying for materials, who are your suppliers, these sorts of things. The particularities of that would be different in agriculture, but the overall approach would be exactly the same, which is share responsibility with your suppliers, make sure that you don't have these sort of punitive unilateral obligations, and then, you know, and also, of course, incorporate human rights remediation, these other things, rather than the alternative approach. So, I mean, we'd be very happy to talk with you more about how to do that for agriculture, but I just wanted to kind of come back to that point. Anything else here? And again, Heinrich, we're talking about cascadance. This comes back to the issue of brands taking a more active role and brands taking a more risk-based role. So they're not thinking, how do I simply limit my risk by getting my supplier to tell me nothing's wrong? How do I really work with my suppliers to go through the supply chain to really identify where I might be subject to risks at any point? So it's a real turnaround in how to engage with risks in your supply chain. And it's your commitment to that turnaround that is being embedded in the contract, because you're really, really saying, I will do this with you, supplier. I will take this on with you, supplier. I understand there are risks and we're both going to have to confront them, rather than just you tell me nothing's wrong, and if something goes wrong, it's really your problem. So it's very much about doing that deep engagement work and actually really understanding your supply chain as thoroughly as you can on that risk basis. Sarah, anything to add to that, or anyone else?
Yeah, I just had two thoughts to add. One is that about, you know, the how contracts, as we are proposing that they be upgraded, can really serve as a way to implement your human rights policies and human rights commitments, right? And so there is a way in which we want to encourage companies to enlist your contracts as allies in meeting up to the commitments that you're making in these other forum, and like approach your contracts as you do your supply contracts and the human rights aspects of those, as you do other parts of your supply chain production management. So that's one point. The other is, just with the minute that we have left, I really wanted to distinguish, because a lot of people here are from the US, to really distinguish disclosure laws from laws and norms that pertain to human rights due diligence. You know, so we have in New York the possibility of having a bill called the Fashion Sustainability and Accountability Act that is very much a disclosure approach to regulating corporate supply chains, human rights and environmental performance. That is very distinct from human rights due diligence, which, as I said, is process-based and has this ongoing, less about setting targets, meeting targets, but more about having this ongoing examination of your supply chain, ongoing interactive mitigation efforts to prevent risks from materializing into harm, and if harm happens, to undertake remediation efforts as well. So it's a real, the shift that we're doing in the contracts is not just about sharing responsibility, it's also about moving to this other system of process-based approaches to improving human rights performance. So that was just a closing.
What a great note to end on. That says it all. That is very much what we are trying to do. I think it is the beginning of a very interesting era in this area, because it is coming up. It's been a very present topic throughout the forum. I never expected to hear so much said about contracts over the course of the last few days. And of course, with the EU also putting this on the agenda, I think it's a topic that's not going to go away. But really, contracts do need to be done in the right way if we really do want to make sure that the human rights in the supply chains are going to be protected. So I hope it's a conversation we will be continuing over the next few years. And yeah, thank you so much for coming. If you would like to reach out to any of us, you will find our emails in the webosphere. Sarah might put them in the chat. But thank you so much for coming, and we hope to continue the conversation.